Hello, my name is Zach McGee. I am the chairman of New Media Legal Publishing, the sponsor of the CLE program you are about to watch. This program was recorded a few years ago, but we've confirmed that the content is still current and reflects the present state of the law on this topic. I hope you enjoy it.
Hello, I'm Peter Afrasiabi, host of the Curious Lawyer series, and you're the Curious Lawyer. Today's program is Shoe Wars, famous footwear and intellectual property battles. You're going to learn it all. And for those of you who have not been to a Curious Lawyer program before, it's edutainment. This is a chance to do something different to your normal area of law. Maybe you are a wills and trusts lawyer and you're tired of going to wills and trusts CLE, or you're a patent lawyer and you're tired of going to patent law CLEs. And you're tired of doing the difficult sort of specialty credits that can be mind-numbing and mind-confusing at times. This is fun stuff to go down an area of law that intersects with you day to day, but where perhaps you'd never thought about the legal overlay and the legal issues. And so here we're talking about footwear. We all know footwear, whether it's our Nikes, our Adidas, our Louboutins. We see these shoes with these cool designs and different treads and different styles. How are they protected? What do you deal with the infringers? I've seen Crocs, I've seen Croc knockoffs. It's all here for you today. So if you are a general practitioner, this is a great way to get an overview of trademark, trade dress, and design patent law. It's sort of an entree into that. If you're representing small businesses who may be in the apparel space and you want to be able to advise them about, hey, you may have more rights and assets than you thought, this program will arm you and educate you about trademark, trade dress rights, and even the need to perhaps go get a design patent right. And if you're an intellectual property lawyer like myself, it's a fun chance to refresh your recollection of design patents and trademark law in a particular niche space of footwear. So let's get going with the shoe wars. Our overview and where we start is going to be where shoes collide with the law. And so what we will address today is a good overview of trademark and patent law for all of you. IP generalist, IP specialists, transactional lawyers helping small apparel companies, or even IP experts who just want a deeper dive into this space. We'll look at trade dress law and trade dress principles, and this is a species of trademark law. And we're going to look at it with a particular application of the shoe space. We will look at the legal doctrines of functionality, secondary meaning, and likelihood of confusion. And then we're going to look at an application of this to some famous shoe cases, our shoe wars. Adidas versus Skechers, Louboutin versus Yves Saint Laurent, Steve Madden, and the Converse Chuck Taylors. And then we will also pivot from trademark and trade dress that can protect the look and feel of a design to design patents, because there's a lot of companies that have actually gone out and got design patents on their shoe designs. And so we are going to get a bit of a primer on design patents and the scope and standards, functionality, the infringement test, and the application of this to the shoe space. And we're going to look at some Nike cases and, of course, Crocs, the ubiquitous Crocs. So let's start with the question, what is trade dress? Trade dress is the design and appearance of a product or the product packaging together with the elements making up the overall image that serves to identify the product presented to the consumer. Retail stores or websites can be included. And so there's multiple examples, and you see here on the page just several basic examples of what can be protected by what's known as trade dress, and it's a species of trademark law, and this is the Federal Lanham Act, of course. And so the shape and design of the famous Coca-Cola bottle is itself protected trade dress. You can even have medical pills protected by trade dress. The color and combination of the pill can be trade dress protected. The layout and look of a restaurant, for example, there's Fuddruckers from a famous Ninth Circuit case involving Fuddruckers, where all of the elements of the design of the interior are protected. You can also think of the restaurant TGIFs, and every restaurant has the same 5, 6, 7 unique elements that together define the overall design and appearance. And of course, in our modern technology internet age, websites can even have trade dress protection in terms of the look and feel and layout of enough distinct elements of a website, all of which can garner protection. Sometimes they don't, sometimes they do, but it would be things such as the color combinations on the website, the fonts, the use of certain kinds of model photographs all the time in certain angles in certain ways. Those types of layout things so that when you go to the website, you know it's associated because of all those elements with a brand. And if a competitor knocks it off, you may trick consumers into thinking that that same kind of feel and layout is now somewhere else. So that's trade dress. Ultimately, where does it come from? Well, on our next slide, we have the Lanham Act. And the Lanham Act is where it comes from, and this is a federal statute, and it provides that any person who, on or in connection with any goods or services, or any container for goods, uses in commerce any word, term, name, symbol or device, or any combination thereof, or any false designation of origin, false or misleading description of fact, or false or misleading representation of fact, blah, 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 shall be liable. And that comes from 15 U.S.C. section 1125A. And trade dress expressly from that list of nouns really comes out of symbols or devices or the combination thereof and the different elements that can then make up the look and feel of something. Now, the Lanham Act defines the universe of things that can qualify as trademarks, and it defines them in the broadest of terms. And this comes from the U.S. Supreme Court. And it says that human beings are capable really of using almost anything that's capable of carrying meaning. And anything almost can become a symbol or device imbued with meaning, associational meaning between that product and the brand or company that stands behind it. This is the Qualitex versus Jacobson case, 514 U.S. 159, and it's from 1995. There's another important U.S. Supreme Court case dealing with trade dress from 1992. It's here, you see here listed 2 Pesos versus Taco Cabana, 505 U.S. 763, and this quote comes from 768. And what the Supreme Court in this case made clear is that the Lanham Act is intended indeed to make actionable the deceptive and misleading use of marks and to protect persons engaged in commerce against unfair competition. The big picture idea being here that people engaged in commerce shouldn't be subjected to unfair competition by others using deceptive or misleading marks. And marks can be a combination of elements of symbols and devices that together as a composite fashion create a look and a feel that's associated with a brand. And so ultimately this is why trade dress as a species of trademark law under the Lanham Act is an area of law where trade dress creates a visual impression that functions like a word trademark. So, for example, the word Nike connotes the brand that stands behind the shoe and apparel manufacturer. The word Xerox may stand behind a copy machine company. The word McDonald's stands behind a fast food restaurant. All of those things are capable of being trademarks, or, in case of Xerox, for example, capable of being lost as trademarks over time, potentially, or arguably. But nonetheless, the same way those words can create an impression or association with a brand, so can the elements of trade dress and a visual impression. Let's ask this question. Do you have to register your trademark? Do you have to register your trade dress? And the answer is no, you don't. Now, what's important to contrast here is patent and copyright law, the 2 other major areas of federal intellectual property law, have mandatory registration requirements. Patents, you have to register to even possess a patent. There's no such thing as an unregistered patent, for example. You can only have a patent once you go through a process and have it issued by the government. Until then, you don't have a patent. There's no such thing. Copyrights, you have at the moment of creation. You don't have to register to have your copyright. But to enforce them in court and to get a whole bunch of valuable remedies if people infringe your copyright, you actually have to register them. So for all practical purposes, there's a registration requirement there also. But on the trademark side, there is no registration requirement. You can register a trademark, but you don't have to. And so what that means is, for example, my law firm is 1LLP, and we operate under the brand 1LLP. If we had never registered the trademark, we would have developed common law trademark rights in the name 1 as associated with a law firm. It's an arbitrary mark, but it's associated with a law firm, and so we would have a developed set of common law rights absent even a registration. But registration is valuable, and we in fact did register, as we wrecked recommend to all our clients to register their trademarks, because registration will give you a nationwide footprint and not limit your common law rights to perhaps a particular area in which you engaged in business or a geographic location. So you get a broader footprint. So there's actually valuable benefits to registering. When we're in the trade dress realm, there's an additional benefit. If you register your trade dress, there is then a presumption that you have shown secondary meaning and you have a legitimate, inherently distinctive trademark. Your mark is presumed valid, in other words. Now, if you don't register your trade dress, when you go to court, you still need to show that this combination of elements for a look and a feel are together as a tapestry set of things, the types of things which can function as a trademark and have developed secondary meaning, and you'll have to prove it and show it. It can be hard to do. There's huge benefits to going each way, actually, and there's huge detriments to going each way. So one, from a litigation perspective, has to think carefully about if you're representing a brand and you have a composite of elements that you believe are trade dress, you want to think about the pros and the cons of going the registration route or not. And a quick few things to think about as you look down the chessboard of litigation is, if you try to go register your 4 elements as trade dress and you get rejected by the Patent Trademark Office because they conclude that those things cannot constitute trade dress, you now have a problem if competitors rip off those elements, because you can't really stop them. You've been told by the Patent Office that you don't have a trademark, and you're going to be out of luck going to court. The flip side, of course, is the benefit of getting it means you don't have to show secondary meaning. Now, if you're worried about maybe the difficulty of secondary meaning and the cost and the difficulty and uncertainty, but you want to preserve the ability to have leverage over potential entrants who may be copying you, then you may consider the advice to your client to be, don't take the risk of getting rejected, leave the playing field open. If someone comes along, we'll sue them in court. We'll take the litigation burden in the court case of having to prove secondary meaning, but we have the leverage over the defendant who's now sued, who itself has to spend a lot of money in litigation, and that uncertainty can result perhaps in some resolution that can also give us some language that may help us in our trademark. So these are the different types of things that you actually do need to think about before you just advise a client to rush off and register trade dress. Let's now look at the elements of a trade dress claim. In order to state a claim for trade dress infringement, a plaintiff has to show that its trade dress is non-functional, as either inherently distinctive or has acquired a secondary meaning, and is likely to be confused with the competing trade dress by members of the consuming public. And what's important here from the US Supreme Court is that product design, and in distinction to product packaging, product design must always have secondary meaning and cannot be inherently distinctive. That's the Walmart case. Product packaging, on the other hand, just like word trademarks, that can be innately inherently distinctive. And this distinction between the two is very important, because product design starts getting very close to the realm of patents, and it's sort of objects that serve a purpose and have a utilitarian function in society. And so the idea that a pen, for example, which is a means of writing, that the design of that product design can be trade dress and have trade dress protection, it can, but courts will always require secondary meaning. They will require that if you claim this pen that I'm holding here in my hand, you claim that you have trade dress rights over it so that no one else on the world can make a pen that's clear in the middle, has a black rubber thing here and black on the end. No one else can do that. You have to then show that that product design has secondary meaning. You have to show that consumers associate this pen with what company is it? The Pilot Company. Got to show it. Let's look at the first element as we unpackage this a little bit more. The plaintiff's burden is to show the trade dress is not functional, and this is important. Product packaging and product design must be non-functional. The trademark laws are not going to let you protect what are functional inventions, because that then gives you a monopoly over a functional item that has to be used to achieve ends in commerce. And the courts will not allow permanent monopolies in particular, which the Lanham Act, you have rights forever. If you're using the mark or the trade dress in commerce, it lasts forever if you keep using it. So if McDonald's is here in the year 2500, they will still have a trademark in McDonald's because they've been using it for 550 years or whatever. Product packaging and design, therefore, in order to have trade dress rights, has to be non-functional. If you have something functional, you want protection over your functional invention, like, the ability to click this thing and have a pen come out the other end, right? If that's your claim for a patent, you go to patents. You don't go to trademark. Now, the rationale, of course, is that time, length, lasting issue. Trademarks can last forever. And this creates a tension fundamentally with the limited patent monopoly, because patents will protect new, non-obvious, novel functional inventions. I mean, patents protect functional items by definition. And if it's new, novel, and non-obvious, you can get a patent. So perhaps the very first person who came along with this pen and said, oh my gosh, look at that, what an incredible invention. It was new, novel, non-obvious. They could have conceivably got a patent on that. And if they'd gone to the patent office and received their patent, they would be the only company on the, the geography of all of the United States that could make that. But the quid pro quo is they can only do it for 20 years, or maybe this was invented a long time ago to mean even less years, but today, 20 years. And then everyone and their mother in the United States can go ahead and make the same click pen. That limited monopoly is really important, because that's the quid pro quo for getting a monopoly and then having at some point it enter the public so other people can build upon it. The Lanham Act cannot therefore be used as a backdoor permanent patent. And so courts in litigation are very sensitive to this, and here's a fundamental practice pointer in this area. You want to be framing your case, depending upon whether you're on the plaintiff or the defendant side, through that lens of what is going on is, either is or is not looking to create permanent monopolies, and those can be powerful policy arguments in terms of how you frame your case. So let's look at the functionality factors courts assess to figure out whether the design is functional, whether this trade dress is functional. And so the factors courts look at is whether the design yields a utilitarian advantage. And so here's a good tip for you. Look for patents in the field on this touted trade dress as evidence of functionality. If someone's claiming trade dress rights in this pen clicking, you want to go see if there's been loads of patents issued on this clicking pen. And if there are, that's evidence really that the invention and the trade dress is actually functional, and so it can't be, trade dress. It has a utilitarian advantage. The availability of alternative designs is a second factor. Whether the advertising touts the utilitarian advantages of the design. Here's a really important tip. Many companies get themselves into trade dress litigation on the plaintiff's side, claiming that their product design or packaging is trade dress worthy. And the history of how they've advertised their product, that they're now claiming is non-functional, is actually often very functional, precisely because it is kind of functional, and that's how you sell the product, by telling the consumers, this is great because it will achieve a function. And I've litigated many of these cases, aftermarket body parts for cars, tire tread on cars, other types of things like this, which can be asserted by a plaintiff as being non-functional. But then when you go look at how, for example, tires are advertised, you find they're advertised in awfully functional ways. They're designed and developed by engineers in awfully functional ways. So you will want to go back and find the evidence of that, memorialize the evidence of that. And one tip is go to the Wayback Machine, the Internet Archives. It's an incredible resource to see how, for example, if you're a defendant, how did this plaintiff treat this pen 10 years ago? The Wayback Machine can tell you. You can go look and see that they talked about it in only functional terms. And lo and behold, maybe they changed their website right before the litigation, where they now talk about how elegant and beautiful it is, and they don't talk about how functional it is. The final factor is whether a particular design, your trade dress design, results from a comparatively simple or inexpensive method of manufacture. So that's how you deal with functionality. The second element is inherently distinctive or secondary meaning. And this requires us to look at really the standard trademark test, where we look at claimed trademarks or trade dress and we figure out, are they generic, descriptive, suggestive, arbitrary, or fanciful? And if you're in the category of the last three, then by definition, as a matter of law, you're inherently distinctive, and so it's capable of being a trademark to identify a particular source. If you're in the first, generic, it's not capable of even being a trademark because it simply refers to the genus of which a product is a species. Now, category 2 is where many businesses find their marks, and that's descriptive. And they're not inherently distinctive, but they can be if secondary meaning has attached through use over time. Now, when we're talking, remember, about product design, it's only going to be protected if you can show secondary meaning because it can never be inherently distinctive. We can't forget that. On the next slide, let's drill a little deeper here on secondary meaning and unpackage what that is. And that refers to proof that the non-inherently distinctive trade dress has become distinctive as applied to these goods or services. The rationale for this is that a term which is descriptive may, through usage by one producer with reference to his product, acquire special significance so that to the consuming public, the word has come to mean that the product is produced by that particular manufacturer. And the crux of this analysis is that the mark really identifies not just the good, but the source, of course, of those goods. And you have to show the primary significance of the term or the trade dress in the minds of the consuming public is not the product, but the producer, the entity that's behind it, or the existence of an entity, just that it represents an entity. And this could be an anonymous one, since consumers, we often buy without actually knowing the personal identity or the actual name of the manufacturer, of course. How do we show secondary meaning proof? Well, there's 6 key factors that courts look at. Whether the people who purchased the product or service that bears the alleged mark associate it with the owner, to what degree and in what manner the owner has advertised under that mark, whether the owner has successfully used this mark to increase its sales, the length and time and manner in which the owner used the mark, i.e. was it exclusive or not, whether the use of the claimed trademark was or was not exclusive, and whether the defendant intentionally copied the mark. Final element is likelihood of confusion, and we're almost now done with our foundational elements, and this really looks at multiple factors, and it's the same basic test in all the different circuits. This is the Ninth Circuit sleek craft test, it's known as, and to figure out if there's a likelihood of confusion between the defendant's mark and the plaintiff's mark, courts look at these 8 factors, and they're not exhaustive. Courts have been able to fashion other ones, especially for the internet era, but the root analysis is focused on these ones. The strength of the mark, is it descriptive? Is it arbitrary? Is it suggestive? Where does it fall? Strength of the mark. Proximity of the goods or services, similarity of the marks, how similar are the 2 companies, that is. Evidence of actual confusion, really important. Is there actually evidence that people are indeed confused by what the defendant's doing, or is this just more of a hypothetical exercise by the plaintiff? Are they using the same marketing channels or different? The types of goods or services and the degree of care likely to be exercised. For example, if you're purchasing a pen, you probably don't pay a lot of attention to who's the brand, and you're not going to exercise a lot of caution. Or buying chewing gum at the checkout stand, you just see something that looks like Wrigley's, you buy it. Maybe a knockoff. If you're buying a Ferrari, on the other hand, you actually use a heck of a lot of care to make sure it's a Ferrari and it's not really a Corvette or something. No offense to Corvette owners. But nonetheless, that's what that factor is looking at. Then we look at the defendant's intent in selecting the mark. Was there bad faith? Were they trying to profit off of someone else's business and consumer base? And then the likelihood of expansion of product lines. With that, now let's turn to our first case, which is Adidas versus Skechers, and we're looking at the famous Adidas Stan Smith shoe you see here. The first case is here reported, 890 F3rd 747. This is from the Ninth Circuit in 2018, and this is our Adidas Skechers case. Adidas, and the basic facts are as follows. Adidas sues over trade dress violations related to its white-green tennis sneaker. And you can see the picture of the tennis sneaker there. And that's that sort of look and feel, so to speak, of the product of Adidas' sneaker. It had never registered its trade dress with the Patent and Trademark Office. But it was very unhappy because you can see there the Skechers sneaker, which is very similar in look and feel. It's kind of got the same air holes in it and some rows going down. It's white with that kind of famous green upper heel portion, similar sole connected to the white upper leather and all that. So Adidas is unhappy and it sues Skechers. And the district court grants a preliminary injunction telling Skechers that it can no longer sell this because it's infringing. And this goes up to the Ninth Circuit, and the Ninth Circuit ultimately affirms. And it's very interesting, and what the Ninth Circuit held is that secondary meaning existed for this unregistered trade dress. So remember, Adidas had to prove secondary meaning. And the Ninth Circuit held that, at least at the preliminary injunction stage, absolutely there was ample evidence that secondary meaning existed. That is, that look and feel of the white, the green, the holes was associated by consumers with Adidas. And how did Adidas show that? Well, they showed that it had been used exclusively since the 1970s by Adidas. There had been no one else using that kind of look and feel for a sneaker. Adidas had expended large resources to promote this product. They had placed it with celebrities and influencers for advertising help. They'd even had unsolicited media coverage praising the shoe as a famous sneaker. Now, there were other issues that existed that created problems for Skechers in terms of this analysis, because Skechers had actually used SEO advertising on the internet to get people who typed in Stan Smith Adidas to then get diverted to the Skechers homepage with their similar looking shoe. And so that was very powerful evidence of bad intent, bad motive, which also affected the court's analysis, of course, as you remember from our factors, on secondary meaning and, as we'll talk about on the next slide, on likelihood of confusion. And so one of the important tips here that you should think about if you're representing a small business that's got, products or services that it sells and it does them in a certain way and it hasn't really dealt with IP lawyers and registered anything, one of the things you can make sure they do is, at a minimum, if they have a set of look and feel stuff that animates how and why they succeed in what they do, preserve evidence of that. Preserve evidence regularly by looking at what you do and what your clients say about it, and go look at what third parties are doing and how they may be distant from you and then encroaching. If they do encroach upon you, you can show that they're doing something to mimic and move into your space. And tip number 2 is a big one. Don't use other people's trademarks in SEO advertising. Skechers just shouldn't have been putting Stan Smith Adidas in a keyword so that when consumers typed in Adidas, they went to the Skechers page. That's a rookie mistake, probably. Now, next slide, you can see what did the Ninth Circuit do with the likelihood of confusion analysis? Well, here again, and there again, you see the picture of the two shoes. And I don't know which one you like better. They both look pretty cool to me, but nonetheless, that's the whole point. The Ninth Circuit said there's confusion, and the confusion analysis favors Adidas. There were unmistakable similarities. They really do look similar. They're very related goods. I mean, whoever wants an Adidas will want a Skechers. It's for the same basic purpose, right? It's a walking shoe or playing tennis or, or cross training or whatnot. So they're related goods. There was absolutely intent to confuse consumers. That was the SEO advertising evidence that Adidas possessed and secured. And so what the court said is, even if we only have a subset of those sleek craft factors, that's enough here to show a likelihood of confusion. This was simply a case of clear trade dress infringement and no less being done in bad faith. And so that's score 1 for Adidas, big hit for Skechers. Now let's continue in our shoe wars. And now we're going to shift to women's shoes, and we're going to Louboutin versus Yves Saint Laurent. And here you see a picture of the famous Louboutin shoes with the red sole. And then you see a picture of Yves Saint Laurent's shoes, which have a red sole and a red upper. And those are the ones that were the alleged knockoff, which upset Louboutin, who has obviously built a huge business with selling shoes that have red soles and contrasting uppers for huge sums of money. I don't know how much, but I think it's like $800 or $1,000 to buy a pair of those things. And so this case comes out of the Second Circuit, and it's reported at 696 F. 3rd 206 from 2012. And the fundamental question that's posed by this case, and it's a really important, fascinating question for trademark law, is can the color red be a trademark? Can simply having a red sole be inherently distinctive, a single color? And so the question then, this gets to some root trademark questions about whether color alone can ever be source identifying. And the answer is that a single color can be a trademark depending upon the facts and circumstances. Not always, but it can be depending upon the facts and circumstances. And so there's no per se bar against a single color being a trademark. And so the question confronted by the Second Circuit was whether the color red, as used on the sole of a shoe, whether it has acquired secondary meaning for the shoes. Now let's stop at one level and make sure we're clear on one thing. Is the sole functional? Well, of course a sole is functional because you need something on the bottom of the shoe to touch the ground so your feet don't fall through and they're protected and it holds up the shoe and all those other things. So a sole is functional. but the color red on a sole serves no function. So there is no functionality argument that can be creatively made by merging what is the trademark, the color red, with the part of the shoe it inhabits, the sole, and saying, therefore, a red sole is always functional. That's not going to work, and that's not appropriate under this analysis. So we are on the question of, can the red sole be inherently distinctive? And so here's what the Second Circuit said. We see no reason why a single color mark in the specific context of the fashion industry could not acquire secondary meaning and therefore serve as a brand or source identifier if it is used so consistently and prominently by a particular designer that it becomes a symbol, the primary significance of which is to identify the source of the product rather than the product itself. So on the next slide here, there again we have our picture so you can keep in mind what we're talking about between the two companies. We have the Second Circuit then holding that Louboutin spent huge advertising expenditures on the sole as the identifier of the brand. They'd had massive media coverage, huge sales success evidence. I mean, they'd sold a lot of shoes at really high price points for a lot of money, and they originated that lacquered red color. Louboutin came forward with consumer survey evidence that very strongly showed that consumers associated that red sole with one unique brand. But here's what's important. What the Second Circuit said is the use of the red sole by Louboutin only applied as a trademark when that red distinctive color was used in distinction and contrast to the upper part of the shoe's color, i.e., it was not an all red shoe, because red was the distinguishing color which required the rest of the shoe to be a different color. And that's the way it had always been. Louboutin's red-soled shoes weren't red on top. That's the basic thrust of what the Second Circuit held. And so what the Second Circuit said is that the red sole was absolutely a valid trademark. A big win for Louboutin to get the Second Circuit to say, yes, you can monopolize the color red on soles of shoes. But Yves Saint Laurent didn't infringe because their whole shoe was red. Now, of course, that meant Yves Saint Laurent couldn't make a black shoe with a red sole. They could only make an all-red shoe. That's our Louboutin and Yves Saint Laurent case. And so let's go in a continued shoe wars here. And now we're going to the case of Aaliyah versus Steve Madden. And here we're actually going to look at a little bit at functionality in shoes and trademarks, because here we have a look at some of these different shoes that were made, and you can see in the drawings of Steve Madden's shoes at the top, and then you can see these shoes called Lulia, Comfy, Catwalk, Bryn Chris. These are made by the Aaliyah company, and Steve Madden was unhappy because Steve Madden had its sort of designs and protections of its shoes that it wanted to protect. And so Steve Madden and Aaliyah are now in a shoe war. And what happened is the plaintiff, this case, by the way, is reported at 2018 U.S. District Court, Lexus 6110, subpages 22 to 24. And with respect to functionality, here's what the plaintiff claimed. The plaintiff claimed that there were three innovative features: the woven pattern of straps with weave notches up from the bottom, an appendage on the heel that extends higher than the weave, and then horizontal grooves on the sole. And what the court said is that it's clear in the court's view that the features for which Aaliyah seeks protection are functional under either test articulated by the Second Circuit. As to utilitarian function, the courts held that common sense and experience suggest that elements such as a strap, raised heel appendage, and woven upper are the features that would help the user put them on and keep them on. And so basically what happened here is, Aaliyah had claimed those innovative features. It didn't like that other shoes were being made that it felt were infringing on its kind of like, appendage on the heel that's higher than the weave, the horizontal grooves going down the side, and then the straps. And the court said, no, that's functional, and you are out of luck. So this is a good example of having to be very careful about what one claims as being the trade dress features of their shoe design, and ensuring that those features that you feel are protected are actually not functional. And so what often happens is a company comes up with a new shoe and makes a shoe, and then a defendant company makes a shoe that looks very similar, and because it looks similar, the first one says, oh my gosh, my trade dress rights have been infringed, and they rush into court. And the analysis that has to be conducted very, very carefully is to filter out the functional and non-functional elements. Are the similarities in what are fundamentally functional elements, or are they in ornamental look and feel things divorced from functionality? And that's very, very important to assess and understand. And for you on the plaintiff side as a lawyer representing those folks, you need to be very careful about holding your client's hand and jumping into a case prematurely. You want to figure out what exactly is ornamental, what's functional, and if the client says, no, 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 this stuff is not functional, it's ornamental, you want to take a look under the hood and understand, how did you design it? Did you design it with functional ends? Did you do testing to see if the grooves would help it grip better or not grip better? Did you do testing on people to see if the heel was at the right height to achieve a certain functional end? Did you attach the strap there for a particular reason to achieve a functional end? How have you advertised it? All of those things become very, very, very important in litigation. And I've litigated, here's an example, some trade dress in shoe cases also, as well as car parts and other things, but in the actual design of shoes. And one of the first things that a defendant will do in litigation is go figure out, oh, that shoe design you have, for example, mine was a golf shoe case. Oh, was the design of the sole driven by function? And I had a case, for example, where we had established in our pre-filing investigation that our client's sole design was developed entirely as an ornamental, design, and they had never done any testing. This is one of the boxes you want to check. Never done any testing at all. Never advertised it as that design as being able to achieve a function. And so you can feel comfortable then that it's not serving a functional master. And so the defendant will assert functionality, but it's probably not going to be a strong defense. And by the same token, you're on the plaintiff's side, one of the first things you want to do in discovery is they're going to charge you with functionality. You want to understand, well, when that knockoff was made, did they design it with functional goals in mind, or did they just knock it off? Did they do testing? Did they advertise it as functional? Because if they didn't, that also becomes an additional argument you have in terms of their credibility even of claiming that the design is functional when they themselves never tested it or developed it or looked at it in that way. And so now let's go to our shoe wars involving Converse. And this is Converse battling at the ITC. And there you see a picture of the Converse design patent that the Converse company has claimed to protect their shoe. And on the next slide, you can see there's a picture of it again. And what we're dealing with is the description of what the mark is actually protecting in terms of trade dress. And the claim is that the protection extends to the design of the two stripes on the midsole of the shoe, the design of the toe cap, the design of the multi-layered toe bumper featuring diamonds and line patterns, and the relative position of these elements to each other. That was the claimed trade dress rights. And I don't know about you, but in my mind at least, those shoes, I've always sort of associated that look and feel, at least with Converse. I just kind of thought it was their look and feel. But nonetheless, this is what happened. Converse, unhappy that things are being imported and it feels knocked off, and so it goes to the ITC to try to get it to issue an order to stop these folks. You have interveners who are functionally defendants. So at the end of the day, what we're dealing with ultimately is a question of infringers making knockoffs and Converse making the originals, and the question is whether those knockoffs are in fact infringers or alleged infringers or not even infringers. And so what the ITC found in Converse's case, and this is reported at 909 F 3rd 1110 Federal Circuit in 2018, what the ITC found is that the trade dress in those elements, and by the way, the reason I mentioned earlier that that's their look and feel and the design and whatnot is because Converse actually registered their trade dress. But nonetheless, the ITC said that trade dress was invalid, and so therefore there was nothing unlawful about third parties importing similar shoes. Now you can imagine that's a big deal for Converse. And so Converse appealed this to the Federal Circuit, and here's what the Federal Circuit held. First, it held that Converse's registered trade dress mark gave a presumption of secondary meaning, but Converse only registered in 2013, And so the presumption of secondary meaning only existed from 2013 on. It did not exist for earlier common law trademark rights that Converse alleged to have had before 2013, and that it was also asserting for pre-2013 alleged infringements. And so, to the extent Converse had a pre-2013 trade dress it wanted to protect, it had to actually come forth with evidence to show, you got it, you remembered from the beginning, you're paying attention, you are a curious lawyer, secondary meaning. And so here's a tip. And this relates to survey evidence that would be relevant for pre-2013. And this comes from the court. And it's an important quote from the court to then internalize, understand, and use as we go forward in litigation. The relevant consumer population for assessing consumer attitudes at a point in the past is a group of consumers at that point in the past. And contemporaneous surveys commissioned for litigation obviously cannot access such a pool of respondents. And so what happened is the case got remanded so Converse could put on its case. It went back to the ITC. The ITC has again sided against Converse, so stay tuned for future updates or go Google it yourself, because who knows the twists and turns in terms of Converse's attempts to protect its trade dress. But the key tip and point here is that this is significant and it's difficult. How do you show secondary meaning if you got to show it way in the past for a pool of people who, with an expert, you can't actually survey? It's difficult. You can do stuff, but you really have to work with knowledgeable IP lawyers and very good survey experts to see how you can construct a survey and what you can do to try to take account of the time issue, as well as look at other sources of information and data that are pre-2013 that could shed light on the existence of secondary meaning through other channels for that relevant time period. And this becomes then very, very important if you're going to make a calculus not to register your trade dress or not have your client register it. It becomes important to then know that if you do register one day and then you want to deal with people and you've got this break like Converse confronted, you need to be able to have survey evidence to address both. This now brings us to design patents, the other major component of today's program, and we're going to look at shoes and shoe designs through the lens of design patents. So what are design patents? The easiest way to think of it, of course, are, you see the pictures there, the design of an iPhone or an iPad, that shape and feel of an iPad or an iPhone, you know, the shape, the lines, the button, blah, 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 trade dress. Now, design patents protect ornamental, non-utilitarian features of an article of manufacture, and this comes from the US Code, the Patent Act 35 USC 171. And so it's very similar to trade dress in the sense that it's about ornamental look and feel and non-utilitarian, non-functional aspects of an article. And so what this means is, as well as registering your non-functional ornamental look and feel as trade dress, you could also go get a design patent. And there are two different routes, and they're different routes, even if it leads to the same place ultimately in terms of being able to stop a knockoff. But they're very different rubrics to go through with very different tests. The trademark route, of course, has that consumer confusion, likelihood of confusion, secondary meaning analysis, fair use defenses. It's a more difficult road to get through in many respects than if you have an issued design patent asserting that design patent against a product. And so we're going to get into this, the nitty-gritty of some design patents to see how the analysis works, and you'll get a feel for the lay of the land in terms of how it can be beneficial to do a patent analysis if you can get a design patent compared to a trademark analysis in litigation. Now, remember, we're just talking today about design patents. Utility patents, other programs, other discussions, other talks, those relate to patents on precisely functional items in commerce and articles of manufacture. So remember, again, we're now looking at simply the non-utilitarian features of products. Think of it this way, cool look and feel stuff. Here's how we understand what is a design patent, since we are talking about look and feel. Pictures, not words, are used to describe the invention and define it. And here's a quote from the most important governing case from the Federal Circuit, at least currently, and it's the Egyptian goddess case. It's reported at 543 F. 3rd 665 at 679 Federal Circuit 2008. And this case says that a design is better represented by an illustration than it could be by any description, and a description would probably not be intelligible without the illustration. The major point here is when you get a design patent, you don't have a bunch of verbiage describing your design, you know, like this, that, and these 3 elements, but not those 2, but this, and this, maybe this. None of that stuff. That's utility patents, where claims are laid out in language and elements and exceptions and all that complicated stuff we have to read and then litigate and try to talk to juries about. No, design patents are claimed based upon a picture. You show a picture, that's your patent. It's a patent on a design. And so you see here on the next slide, here's a shoe design patent. And literally the claim of the patent is that picture. That's all you get. So you actually get your design patent issued, and really all it'll say is what is claimed is a sole of a shoe design as depicted in the following 8 illustrations. And then you just have 8 pictures in your little patent. And so here we have some important principles, though, about interpreting design patents. And the figures of the patent define the one claim. So there's one claim, this shoe sole design, but there can be multiple figures looking at it from different angles, and all of them together constitute the overall invention and one claim. Broken lines in the drawing are not part of the claim design. And the fact that the shoe bottoms can have 3-dimensional aspects doesn't change the fact that the ornamental design is capable of being disclosed and judged in a 2-dimensional or planar view perspective. So the very fact that you have a 3-dimensional object like the tread of shoe or the tread of a tire, for example, doesn't mean that the design has to be depicted in the same 3-dimensional XYZ axes. You can use a 2-dimensional viewpoint that depicts where the objects are on the shoe bottom so that you can understand that there is actually a 3-dimensional thing. And so patents are not going to be held invalid simply because the shoe tread may be 3-dimensional, but the picture is 2-dimensional picture, in other words. And this is the In Re Matita case. This is our first shoe design patent case. You can see it's at 900 F. 3rd, 1369 from the Federal Circuit in 2018. And that's kind of an example of sort of the design of the shoe that they wanted to protect. They didn't want anyone else to have a design like that. They claimed it was all ornamental, it was not functional, and it was important to that company, obviously. And so that's an example of how you can go that route rather than wait for a knockoff and then go the trade dress route, where imagine if you're in the trade dress realm, you would have to convince people that all of that stuff in that shoe, I don't even know how to describe it, but that look and feel kind of spider thing in the middle, those trapezoidal elements at the end, the kind of growing circles through the middle, you'd have to convince consumers and judges that all of that has some secondary meaning and it's associated with someone, and that people are likely to confuse someone else's shoe with your shoe. Functionality. This comes from the Benito Boats case and from the Federal Circuit case of Hupp versus Seroflex, but here are the key points to just remember for functionality. It's a lot like what we talked about in functionality before when we were talking about trade dress. To qualify for protection, a design must present an aesthetically pleasing appearance that is not dictated by function alone. And that is from the U.S. Supreme Court. From the Federal Circuit Hupp case, you see reported there, we have the following quote. Although the design patent is directed to the ornamental aspect of a useful article, that the design of a particular article is related to the article's use may not defeat patentability. When the design is primarily ornamental, although it also serves a utilitarian purpose, this design patent condition is met. The fact that the article of manufacture serves a function is a prerequisite of design patentability, not a defeat thereof. The function of the article itself must not be confused with functionality of the design of the article. Really important distinction to keep in mind as you assess functionality. So now let's go look at infringement, because remember, we don't have to deal anymore with secondary meaning and all of those factors for likelihood of confusion. We have a different test. We're in the design patent land, and here's the test. Again, from the Egyptian goddess case. The infringement test juries apply in design patent cases to the construction and then infringement is the ordinary observer test, and it simply posits the following. A design patent is infringed if the accused article is substantially the same as the claimed design in light of the prior art from the perspective of an ordinary observer who is a purchaser of the type of goods. So, if the shoe design is sufficiently similar, substantially the same, to your average shoe purchaser who's looking at the shoe design, then you can show infringement. substantial similarity, and you're often running as a plaintiff and you're in trouble as a defendant. And this ordinary observer test, giving the type of attention that ordinary observers give to that product at issue, goes back. This goes back to the U.S. Supreme Court over 100 years ago, or actually over 150 years ago almost, in the 1800s. Now, damages and marking for design patents. There are some potent remedies that design patents give you, but there are some quid pro quo requirements you have to engage in as a patentee. The most potent remedy is that a design patent plaintiff can get all of a defendant's profits. That's from 35 U.S.C. 289. And here's what the statute says. Whoever, during the term of a patent for a design, without license of the owner, applies the patented design or any colorable imitation thereof to any article of manufacture for the purpose of sale, or sells or exposes for sale any article of manufacture to which such design or colorable imitation has been applied, shall be liable to the owner to the extent of his total profit, but not less than $250, recoverable in any United States District Court having jurisdiction. That is a powerful remedy. If you unpackage it, what you realize is you can get the entirety of the defendant's profits, all the money they made selling the knockoff shoe. Contra, if you're talking about normal utility patents, you can't get such a deep reservoir of damages. You're not entitled to all of the defendant's profits. You need to get your actual caused losses or some sort of reasonable royalty. And a reasonable royalty could be way less, obviously, than their profits. And so design patents, actually, this powerful damages remedy, which has been affirmed by the U.S. Supreme Court, this has made design patents, especially in the last 10, 20 years, become even more valuable. And so if you're a general practitioner, for example, representing small businesses who are creating products that they're selling and they're worried about knockoffs and their consumer products that may get knocked off, you should think long and hard about getting a design patent. Talk to patent lawyers about getting a design patent, because it can be a very powerful tool to deal with infringers and essentially put an infringer out of business, so that you're not stuck having to deal with a very difficult trademark analysis, or on the utility front, you may get a reasonable royalty, which means it's effectively profitable to infringe. You just get a royalty back, and that's where you are. Now, the quid pro quo, of course, for damages in the patent world is that you have to mark the patent number on the article to be eligible for infringement damages. And that's from section 287 of the code. And so, you simply need to put somewhere like patent in the number. And so, I don't know, if you're not paying attention right now and you want to take off your shoe and check the tongue of your shoe and look at it, you may well see that it's got a patent number in there, because Nike, for example, if you're wearing Nikes, marked the patent. Louboutin, I don't have any idea. I've never held one or seen one. Too expensive for me and my family. But there's probably, if they have a design patent, don't know if they do, it appears they've gone the trade dress route, because it's color. You can't really get a design patent on a color, but maybe they have some cool shoe designs they've got design patents on. It could be embossed inside the shoe. It could be on the box the shoe comes in. It would also be recommended to put it on the website, even as well as fixing it to the product, in advertising, marketing literature, so that there is clear statement everywhere and you have that valuable evidence that you have marked in every source possible that this product is patented. So my tip at the end of the day, look at your client's portfolio of products to see if they could get design patents somewhere. This now brings us to Crocs. And here we have a picture from Crocs' design patent for the ornamental design of their footwear. And what happened is their ornamental design of footwear ends up being challenged in another ITC proceeding. And the patent right there is the depiction of their iconic foam molded clog design. And that's how Crocs described it, as their iconic foam molded clog design. I don't know, I actually think it is kind of an iconic design. I remember when it first came out, it was like way crazy cool and different. Now, in the ITC found that none of the infringers, the interveners, but the putative infringers, none of them infringed this design patent, because the ITC assessed the scope of this design patent based upon verbal descriptions instead of just looking at the overall pictures and comparing them. So let's go to the next slide, and you can see in our left set of pictures there are the Crocs, the drawings from the patent, and on the right are the defendant's shoes. And if you're confused who's who, so am I. You're right, they're awfully similar. Now, here's what the ITC did. The ITC saw Crocs' design patent as requiring a non-uniform strap and as requiring evenly spaced holes. And it did that because it looked at those pictures and said, oh, look, your strap is not uniform. It gets bigger around the back of the foot and then, it comes back in. And the holes aren't like uniformly spaced. And so then it looked at the red shoes and it said, well, wait a second, that strap is the exact same size all around and the holes are not evenly spaced. They're a little more offset in a different way and it's a different kind of hole pattern. And so the ITC said, therefore, we've compared the two and there's no infringement because those minor differences in our red shoes there made it not infringe. So you see again, the ITC not friendly to shoe companies trying to protect their shoes. We saw it earlier when we looked at the ITC dealing with Converse. Now we're dealing with Crocs, and I don't know why the ITC doesn't like shoes, but the case went to the Federal Circuit, and as with the Converse shoes, so it is with the Crocs shoes. The Federal Circuit seems to protect our companies and their shoe designs. And the Federal Circuit reversed, and the Federal Circuit held that the ITC placed an undue emphasis on verbalized small differeces as opposed to that Egyptian goddess analysis of how would an ordinary observer analyze the overall similarity. And here's the quote from the Federal Circuit. These side-by-side comparisons of the 789 design patent and the accused products suggest that an ordinary observer familiar with the prior art designs would be deceived into believing the accused products are the same as the patented design. In one comparison after another, the shoes appear nearly identical. If the claimed design and the accused designs were arrayed in matching colors and mixed up randomly, this court is not confident that an ordinary observer could properly restore them to their original order without very careful and prolonged effort. In other words, very small changes to the straps or the hole spacing and you make these minor tweaks to try to get around someone's design patent, probably not going to work because remember that test is elastic, substantial similarity to the ordinary observer. So if there's a design patent out there, now you're on the other side, you're a practitioner, you want to make a new shoe and your client comes to you and says, oh my gosh, I got this great new shoe I'm going to make. Yeah, it kind of looks similar to their shoe, but I made some changes. Don't worry about it. Pause, tell your client, worry about it. Tell them about this case, look at this case, definitely get a design patent lawyer on board or a trademark lawyer on board to do an intellectual property assessment to make sure you're okay. And this goes to one of the myths out there, which is you make small changes to a patent, you can get around the patent, you're okay. Not true. There is the substantial similarity test, doesn't require perfect linear counterfeiting. And then there's also the doctrine of equivalence, which allows some breathing room in the claims of a patent anyway. Now, let's shift to Nike, and we're going to look at this Nike shoe here you see in the picture, and we're going to use the Nike case to explore marking. And so this is a case of Nike against Walmart. And what happened here is we don't need to worry about infringement because Walmart was selling shoes made by a third party that were literal knockoffs of the Nike shoe. I mean, it's just straight up infringement of that design patent. And so Nike won. They were basically identical. But there was a marking issue. Nike hadn't fully marked all the shoes. And so what the district court held was that, well, the marking requirement doesn't apply to Nike's damages claims, only if Nike wants to disgorge the profits of Walmart. And so therefore, the fact that it didn't mark everything doesn't matter. And what the Federal Circuit held was that that's not true, and the Federal Circuit reversed. The marking requirement applies to any kind of damages you want under the Patent Act, regardless of whether it is their lost profits or your desire for a reasonable royalty or your lost sales, you have to mark. And so ultimately what happened in that case is that the Federal Circuit remanded the case so that the district court could figure out the factual issues about the scope of marking. And what was apparent on the factual record of that case is that Nike didn't mark its shoes the moment it started selling them. It started marking them a little later. And so that would mean that there's a window of time where perhaps the knockoffs were sold, where if Nike hadn't marked, Nike wouldn't be able to get damages for that window of time. And so then the question would become, once Nike started marking, what is that window of time for damages? And of course, you know where the defendant would be going there. Walmart would be saying, well, you never marked in the beginning, and so there's a latches or a estoppel type thing that allowed us to believe we had the right to do this since there's no patent on it. And so even when you started marking, it was too late because we had already, we're already the beneficiaries of latches or estoppel. In any event, those are the types of defenses that can come up. And so the point of this case, of course, is, holy cow, marking is really important. And My goodness, the idea that you could lose out on what is such a powerful damages remedy after investing money in a lawyer getting a design patent and you forget to mark, absolute disaster. Mark, 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 mark. This brings us to our conclusions. And our major conclusions today in today's Shoe Wars program is that trade dress is an important remedy that allows you to protect non-patented, non-functional product packaging designs and the look and feel. And it distinguishes from patents in the ways that we've talked about, but it's also very important because maybe your clients didn't have the money to get a patent, didn't get a patent, and if they've been selling the product for more than a year, they can't even get a patent anymore anyway. So all you have left sometimes to protect the ornamental, non-functional look and feel of something is trade dress. And so you want to then assess the viability of that and be aware of confusion-related evidence that's critical to keep so that we know we have records and data that show what consumers were saying in social media at the time that mattered. Tell your clients if they're doing that to preserve it. If people are posting on Instagram, thinking that someone else's product is associated with your product, preserve it. It's evidence that an expert can rely on to show confusion. Expert evidence is always crucial in trademark cases because you've got a lot of expert-driven issues. Secondary meaning, likelihood of confusion, those things are expert-driven and expert expensive. There's that fine line of functionality that you have to tread carefully. And remember, there's no registration requirement. And so there's no risk of seeking protection and losing. You can leave your placeholder there to go to litigation if you have to and air it out in litigation where you may have a little more leverage and control over the ultimate outcome that you're desiring as a plaintiff. The flip side is on the patent side. If you're developing new products and ideas and your clients are they have new designs, register a patent and get it on file before they've been selling the product or showing it to the public for years so that you can actually get that design patent issued and protected. And you may want to consider it. It's an investment of several $1,000s as opposed to investing nothing and then going for trade dress. But if you get that design patent and it's a really good one, then you have the arsenal of easier litigation, more potent damages remedies at your disposal, not as expert intensive and as expensive. And again, same functionality expert things could be driven as in trademark. So you still have to be looking at functionality and making sure that when you go get that patent and you represent that it's not functional, you're telling the truth. And remember, mark your product, mark the website, mark the advertising literature. Marking is critical to get those good remedies. As ever, I hope you've enjoyed today's Curious Lawyer program. If you have questions, you want to talk more about design patents or trade dress or litigation strategy, as always, feel free to email me. I love getting emails and responding to them. It's always fun and interesting. Have a great day.